Well, good afternoon. Thanks everybody for spending some time hanging out today and thinking about all those fun things going on out there in the world of ed tech, data privacy, AI, electronic records. We've got lots of things that are out there. And so, as we do these things a couple times a year, I've tried to focus on a few of them that I think are important for purposes of our conversation today. And really, we're going to spend some time covering three areas: AI and some emerging issues and questions and discussions where the law might be going, and some of the legal issues that might pop in that regard. I want to talk about data privacy and cybersecurity in the context of the Department of Ed's recent rollout of some of their cybersecurity initiatives at the federal level. So we'll talk that through. And then handling electronic records and records requests, FOIA requests, student records requests, requests for all the emails, those things that we're dealing with on an increasingly frequent basis. And we want to be prepared and ready to think about as we work through that today. So let's jump in. And as Matt mentioned at the outset, if you've got questions, feel free to pop those into the comments, and we'll try and answer those as we can as we go. But let's jump in first and really think about these questions about AI and what it really means and how it is impacting us in different ways. And I think one of the things that so oftentimes happens as we see quick advances in technology is that we're trying to play catch up a little bit. But what almost always happens, right, is that we have to take the legal issues as they exist in the analog world, in regular day-to-day life, and other things, and try to apply them in these areas where we have emerging technology. That was true for us when we think about things like social media, where we had to take long-standing First Amendment case law to, when we used to talk about letters to the editor, then we're talking about posts on Facebook. And then we, start to move on to things that might be, emerging with changes in technology. And certainly the same thing is happening here. But I do think there are several areas that we need to really think through what it really means. And I think some of the big picture questions that we have to first answer, as a school district is, do we need formal policies that are specific to AI, or, do we let our existing policies, do that work for us? I do think for the most part, like we do in so many areas, our existing policies are probably the right policies to have. And hopefully they're written in a way that gives us enough flexibility so that we apply them to situations that might come up. I do think there might be specific procedures or issues, and we're going to talk about what some of those examples might be, where as a district, we've put up some guidelines or parameters, perhaps through policy, perhaps by applying existing policy to new technologies and new platforms and new ways of thinking about things. So I do think that we're going to think about those areas where policy might become important for us. I also think that we've got to be prepared on the training side. Should we be training students, staff, parents, everybody in the community about good versus bad uses? And like all, aspects of technology, there are good and important and helpful uses to AI that we don't want to squelch. At the same time, we want to make sure that we're not using it for things that it's not intended for. And I think the other question we get oftentimes is, to block or not to block. Do we let it? Do we not? And I think that answer goes back to those first two questions in terms of, I'm concerned that if we get too far towards we're just going to block all these things, we're losing out on what I think are some of the important and good uses that could be there for us. And we're also missing out on a learning opportunity where we're going to have to teach kids those things, as part of our curriculum. And I think that because technology is not only a mandated part of our curriculum in many ways, but also I think an essential one because of the reality of the world that we live in. I think we have to figure out how we play that out. And I think there are several areas where we see concerns noted, that I think that there are challenges that we are going to have to be ready, willing, and able to address, but that there are solutions to that. And that we're going to have to, as a school district, think about what those solutions might be. One of those clearly is in the data privacy side of things. And that with AI, it does create certain risks for data to be exposed. So I think that we want to make sure that we've got some, proper cybersecurity coverage. We're going to talk about that in sort of our second component of our conversation today, more generally, and in the context of the Department of Ed's recent guidance and initiatives, but making sure again that that's compliant with state law in terms of our SOPPA requirements, to make sure that that is there, so that we don't have these third-party vendors, these third-party platforms that might be using AI that's mining data that should otherwise be private. So we have the right security measures in place. I think that's an area that we've got to make sure that we're paying attention to. I think the second is the potential bias that might exist in AI, because we recognize that because humans are biased, AI is going to sometimes reflect those. And so we want to make sure that we've got proper training so that AI is not making the decisions that sometimes professional educators or trained staff ought to make. We see this in a couple very specific ways I'm going to talk about, like in the special ed world already. But we want to make sure that when there does make time for somebody to make a decision, exercise discretion, that we are doing that as the humans and not letting technology make those decisions for us. Job displacement is a reality with AI, right? Any time of technology comes in, it might replace certain roles, but we can find ways that it can increase efficiency. Ultimately, it's not going to replace the need for high quality teachers, but there are certainly lots of aspects within the school setting where there are places where we can use this to increase efficiency. In the legal world, that's always a concern. There's, all these posts, will AI replace the need for lawyers? Why do you need to ask your lawyer a question when AI can give you the answer? Well, what we're realizing is oftentimes AI is not giving you the right answer, that sometimes it's, making judgment calls based on limited information, that we don't have that human element of being able to use some discretion and looking at context. So that's going to be important. Fourth, issues of transparency, where we want to make sure that we can explain really what's going on so that staff, students, parents, the community understand what's going on, what policies are in place to protect people, what the restrictions are. So making sure that we do have that transparency, and then some accountability so that there is some ultimate responsibility through policy, through the procedures we put in place, to make sure that we understand what we're supposed to do. So let's talk about this in a couple very specific ways that this may pop up within the school setting. And one of those is in special ed. There are a number of platforms out there already that many school districts are subscribing to that start to use some form of AI to populate present levels, to write IEP goals, to suggest curriculum interventions for students. And I think that's awesome to the extent it's appropriate, right? And we want to making sure that when the IEP team is making a decision, that still has to be an individualized decision as required by law. And so it can't be a automatic, decision about IEP goals or curriculum or decisions about programming. And again, to the extent that those tools allow us to improve our IEPs, to improve our decision making, to make writing IEPs less burdensome and less of an encumbrance on staff, so that they can spend their time really providing the instruction to students. Again, great. But there are limits, right? And we're starting to see where, AI generated IEPs may not always be fully appropriate or fully individualized. That's one area where that pops up. We also have some of those confidentiality issues that are out there for us to keep in mind as well. We see headlines recently about some of the copyright issues that are out there, where AI might be borrowing from copyrighted images or other work, copyrighted written material and text, and then using it to generate answers in a way that might impact whether it is in fact copyrighted, might be violations. So when AI is looking for sources of information upon which to make decisions and generate content, the privacy, the confidentiality piece is still important, so that we aren't crossing those boundaries where it ends up being used for purposes or in manners that the law would not permit us to. That's certainly there. And then we've got some First Amendment and some free speech issues. Obviously the AI itself is not subject to its own free speech under the Constitution, but as humans we are when we use it. And so we see that in places like deepfake videos. That has been probably one of the more frequent concerns from a student discipline and First Amendment perspective that I've seen cross my desk over the last year, are where students are creating deepfake videos of staff members, of other students, where it looks like they're saying or doing things that would be inappropriate, and being able to determine that they are in fact deepfakes. Can we discipline for that? There is a recent case that I think suggests that we might be able to do that when we start to think about that difference between parody being protected by the First Amendment or something that truly might be harassment or threatening in some way. Also seeing this as a revenge porn situation, where we've got students sometimes creating pornographic images of classmates, and that creates a child pornography issue. Those are some things we have to be on the lookout for. But I think the case that's probably at this point closest on point, we don't have yet that true AI or deepfake school case yet under the First Amendment. I think the one that comes closest to it most recently is the Sixth Circuit decision from this year, the Kaczynski case, which deals with creating a fake Instagram account for a teacher. And so this idea of impersonating another person's identity, posting things online that makes it look like they are posted by them and from them. And so again, while this isn't technically a deep fake and it isn't technically a form of AI, again, I think that this idea that, the posts here included not just benign content, some of which that it was, but also graphic, harassing, and threatening content, sexualized content directed towards teachers and students, and that there was some disruption here. And the court said, look, we think that this, even though it was a teacher who was the target of this, that this falls within the Supreme Court's carve out for that off-campus social media conduct, that might be defined as serious or severe bullying or harassment targeting individuals. And ultimately they found that the student here was responsible for that and therefore could be disciplined consistent with the First Amendment. And I think that we again see the same thing in some of these more AI generated or deepfake type situations where it's impersonating another person. The courts have been more willing to say that might fall within that serious or severe bullying or harassment targeting individuals. And so I do think that there's some flexibility there from the legal perspective. So I think that's the first third of our conversation today, is to think about that AI piece and where that's going. I go back to those big picture questions about, just to jump back here to this earlier slide, do we need formal policies? I think there are going to be areas where, as this continues to emerge, our policies are going to have to keep up with the technology. We're going to have to recognize, I don't think it's a matter of banning it or blocking it. It's a matter of finding out the appropriate uses for it and provide training and support for that to work through some of those challenges that exist for us. So that's the first area. So certainly, again, as you guys have questions, we can talk that through and pop those in the comments. But that's sort of topic one in our trends today. I think the other piece, and not too far afield from that first one, is really thinking about some of those data privacy and cybersecurity issues. And, I know this is something that I've talked about before, to probably some of you who are joining today. But I do want to point out something that I think is an important point here are some of the more recent initiatives from the Federal Department of Education. And this fall, they did release several cybersecurity resilience efforts supported at the federal level. And we want to make sure that we understand what's in there, and what's, what they're recommending to us from that perspective. There's an example here, that shows up in their guidance document to kind of suggest how in one very specific context, we see a number of situations where cybersecurity issues pop up. So here, a middle school principal opens a pre-meeting of school personnel who are part of an upcoming IEP meeting to discuss, the student's IEP, to get ready for an IEP. And the case manager starts by pulling up a school-wide dashboard showing trends in the school's academic attendance and wellness data, and how that student's data aligns to school-wide data. So the first thing here, we're opening up information that's got both de-identified student data, and it's got this student-specific data where there's access issues. So we've certainly got, information that's out there in the team starts to navigate through the student's profile. It includes their picture, their grades, their attendance, their IEP goals. And there's discussion about those points. And then the speech language pathologist says, let's talk about assistive tech. This is a student who might need to be evaluated for the use of an assistive tech device. And how do we train for that? And how we collect data? And how will that device be protected against cybersecurity risks or data privacy breaches that might be there as part of that? And how do we walk through those types of things? And so, and again, here's the Jenna teacher says, well, let's talk about some notes about the family's participation in our community's affordable connectivity partnership through local internet providers. And if we're providing those supports, where does that create a cybersecurity risk as well? And so again, we can see in the context of one meeting, we're walking through situation after situation where cybersecurity is in the background and is lurking, and some of those issues we have to be ready to think about. And so the Department of Ed suggests several areas that we need to be focused on as schools to work through some of these initiatives. Ongoing continuous risk management. So we're always realizing that there are inherent insecurity in all of our digital platforms, all of our technology infrastructure, and we've got to always continually reduce that risk. As technology changes and increases, the risks become greater, and we've got to make sure that it's not like a one-time thing, like, oh, we fixed it today. That is a constant vigilant effort of risk management. And I think another point, just like we started out today, make some analogies back to the physical world, like school fire safety, to help everyone understand and address those challenges. So really training in a way that's meaningful and understandable for all users, even if they may not speak tech language, right? I think that is important for us to keep in mind. We've got to prioritize those risks and make sure that we've got those mitigation strategies being implemented. And, there's some specific recommendations we're going to talk about that have come through the Department of Ed's cybersecurity initiative this fall. We prepare for when, not if, so that we understand there are going to be cybersecurity incidents. These things happen, and making sure that we've got a plan, we've got the right backups, all those things in place to be able to make good decisions, and that there's a role for vendors. That and as we're going to see in a little bit, some of the data suggests that oftentimes that's where we see some of the risks, is where we're sharing data with other parties, with third parties, so that our vendors are also prioritizing those cybersecurity measures, which we know by state law is required in Illinois, right? For those SOPPA requirements to keep in mind, and that those are some important recommendations from the Department of Ed. So some of their high impact recommendations, we're prioritizing some of those unique challenges and some of those malicious actors. We usually see 3 ways that are most frequently, and they say, compromising valid accounts because they have weak or stolen credentials. If our password is 1, 2, 3, 4, it's not gonna work. My 6-year-old has a little journal that has a electronic password on it, and one of her friends was over and opened up. She's like, how'd you open it? She was like, your password was 1234. You're going to have to come up with a better password than that. But those, again, are some of the things that we have to train staff on and emphasize the importance of that. There's a reason why we don't leave the key to our house hanging on the door or visible to others. And I think that's important. The second area where the Department of Ed suggests we need to, again, prioritize are those phishing attacks, those malicious links or attachments, and training people how to recognize those, how to avoid those. That's an important part of our reasonable security measures we're required to think about under SOPPA as well. So making sure that we're getting staff trained well on recognizing and avoiding those. And then, of course, when we see those unpatched vulnerabilities in our public-facing applications, that's the other place that we see that coming up, and we want to make sure that we're paying close attention so that we are mitigating some of that to the extent possible. And the recommendations that how we can really impact that are, again, through multi-factor authentication, strong unique passwords for every account, recognizing and reporting phishing for all staff, and keeping all software up to date. Those are the highest impact recommendations. Probably not a surprise to any of us. Again, that efforts at risk management becomes really important for us to keep in mind. I also just want to share, again, if you take a look at that, they gave a ton of links to other resources that can be really helpful. And so I encourage you, there are a lot of great resources here at the state level through LTC and others, but really making sure, there's some of these recommendations here from the feds that are out there. So there are a lot of considerations, a lot of guidance documents out there to provide to staff, to provide to students, to use for curriculum, to have some checklists like data breach response checklists, those types of things that are out there for us to keep in mind. So, again, as we're trying to bolster our risk management, take a look at some of these recommendations as well, because I think that that's helpful, especially in averting liability, because these things are going to happen. And if we're ignoring some of the resources that are out there from the agencies that are responsible for giving us that information, that's where liability concerns certainly pop up for us. But all of it comes back to us as humans, right? The reality is that nearly all security breaches come from some type of human error. And so whether that's weak passwords, compromised emails, rogue employees, an employee just error happening, being susceptible to a phishing attack, those are all things that certainly pop up for us, and we want to pay close attention to and understand what's going on. And in the 2022 annual report from the state of K-12 cybersecurity, they noted that it's other vendors that tend to be a big factor, and so we want to make sure that we understand that this is something that we have to not only require of our own employees, but all of the vendors that we're working with as well, which is something that's required under SOPPA, and something that we have to take seriously as, part of our approach to that situation. So again, I think some of those questions that we have to continually ask as part of our continuous risk management and our approach here, do we have our privacy and ed tech committee prioritizing some of our cybersecurity issues? I remind you of the existence of that committee, which probably exists by policy in your district. And I say that because most districts in Illinois use the press policy service. And within press, it assigns a lot of those tasks to an ed tech committee and defines who might be on that committee. So do we have that committee working and prioritizing some of these issues? Again, looking for those priorities to proactively fix some of those concerns for us, training employees in ways that are meaningful. I think about all the ways that we provide training to employees, and to make sure that we really are getting understanding, especially as part of the adult learning cycle. As adults, we learn much better in a hands-on and experiential way. And so being provided a memo about what we're supposed to do or not supposed to do isn't always the most impactful and meaningful way to understand how to avoid a phishing attack, or how to make sure that if I'm accessing the network remotely or accessing student information system remotely from home, where that weak point in cybersecurity exists and what to be doing. So again, making sure that our vendors and operators are maintaining those safeguards as well, and requiring that by contract as SOPPA requires of us. And again, this being a consistent practice of reassessing and reevaluating how successful our program is. That's something that's really important for us to keep in mind. Again, looking at some of those technical safeguards that we want to keep in place in terms of our network design, what software we're using, our storage options. Are we encrypting our data? Are we not? How do we transmit data? How are we detecting those failures and those things, and monitoring those systems? So to make sure we have in place those technical safeguards that are necessary to keep things safe, that there's sometimes the physical safeguards of things. Where are things physically stored? Is it in a secure room? Is it a locked room? How do we, make sure that we don't have unauthorized access to that? So not just the security, but also the physical security of those things as well. So as we, continue to think through those cybersecurity issues and how that plays out for us, I do encourage you to go back. I think there's some good information in a lot of that updated guidance and those new initiatives from the Federal Department of Ed, which might give us some additional clues, some additional insights, maybe some things we've overlooked, to make sure that we're staying up to speed and, fully implementing those reasonable security practices that are required by SOPPA here in Illinois, but are certainly just the best practice, regardless of that, and things that we've talked about and trained on even before SOPPA went into place. So I think that's something that we keep in mind. So that's sort of the second piece of our conversation today, is really focusing on that cybersecurity piece and what's out there. So again, if you guys have questions, pop them up. We'll certainly have plenty of time here at the end for some Q&A. So we'll think about that as well. But the third area that I want to spend some time on today, and then we'll turn to the Q&A after that, are issues with electronic records and records requests and how that comes up for us. The reality is that we as a school are creating on a daily basis tons and tons of electronic information and communication that people may have a right to access, And so when we think about all the ways our staff communicate by email, text message, chat, through WhatsApp, the voicemails we leave that are all now, VoIP types of situations, we're creating all of these electronic records. And do we have in place, if, for example, as happens on a daily basis, right? You get a request from a parent that says, I'd like copies of all the emails between staff concerning my child from the beginning of time until today. They're likely entitled to all of those, under a student records request, with some very few exceptions. And how are we going to search for that? What systems do we have in place? Our staff understanding that if they're texting each other about a student, that there might be an issue. I've sat in an IEP meeting where it's pretty obvious to the group sitting at the table that you've got two staff members who are texting each other during the meeting. And the parent attorney said, I'd like a copy of those texts. And if they're concerning what's going on in that meeting, if they're concerning the student, they're entitled to that. So have we trained staff, refreshed them on that training about student records laws, and when we create a record, the implications of that in terms of access and maintenance and how long we have to maintain, records and all of that stuff. And of course, there's the impact of FOIA, where, all district records are presumed to be public records unless we can narrowly point to one of the exceptions in the Freedom of Information Act applying. And we have to be ready, willing, and able to understand that presumption of access. And so I think an important piece here is for us to think about how we train staff about the records they're creating. And then when we create all these records, how we maintain them, how we search for them, how we deal with requests, we have to have a system in place to be able to do that. And frankly, when we start to look at the case law, the decisional law, the decisions from the public access counselor of the Attorney General's office, who has the authority in Illinois to oversee FOIA and make determinations on FOIA complaints, they're looking at those in a very specific way. Here's a hypothetical, right? You've just returned to your office from a wonderful LTC meeting. You're all probably sitting in your office now. There's no return. You're there, but it's over. And you get an email from a parent's advocate requesting copies of all education records for the student under FERPA. And the advocate specifically notes that these records should include all emails, text messages, Google Chats, WhatsApp messages, and voicemail. Of course, the tech director is off today, and we've got to figure out how to respond to this. Do you A, ignore it because it came from the advocate, not the parent? Do you B, call your staff in over the holiday weekend to gather the requested records? Do you C, provide copies of the last IEP but not the electronic records? Or do you diligently work to collect those requested records, provide them to the parent in the timeline required by FERPA, the IDEA, and the Student Records Act in Illinois, and work on staff training about proper electronic etiquette moving forward? Anybody want to vote in the comments before I talk these through? I think that we can start to eliminate a few of these, right? Obviously, A is not correct. We can't ignore it. Now, we're going to have consent to provide the records to the advocate, but the fact that it came from the advocate does not allow us to ignore the request. And C, of course, is correct because, the electronic communication are likely going to be have to provide too. I see an option thrown here in the comments. E, crawl under a blanket and hope it all goes away. If only, right? If only. Now, so we're left with B and D. And I think the right answer here, the best answer here is D, right? I don't think we have to go with B because the Student Records Act gives us 10 business days to provide those records. So we don't have to call staff in immediately over the weekend to do that. We don't want to delay too long because that could be an awful lot of records, right? And so we're going to have to move on that pretty quickly, but that timeline is 10 business days. So we want to keep that in mind and recognize that's how we have to handle it. But at that point, we've got to ask those questions. How can we effectively come back and look at what those records are? And so again, I think one of the things that frustrates me is all the texting, right? How do we make sure that staff are only creating the records that really need to be created? And my advice to staff is your personal accounts are for personal business, your school accounts are for school business, and we're not going to mix the two. I'll tell a happy story-ish, on my own daughter's teacher. We love our kindergarten teacher. She's a brand new first-year teacher this year. She's great. I remember sitting there in the, parents' night before the school year began, excited and nervous as, my first and only is headed to kindergarten. And, she's doing a lovely job of going through all the way, here's how to call my classroom. Here's my email address. Here's how to contact me through Class Dojo and Teacher Ease. And then if you want to text me, here's my number. And I want to be like, stop there, right? Let's just stop there. There's all those other great ways, email and Teacher Ease and Class Dojo. We don't need to get to the texting where we're creating records now that we may have to maintain and access in other ways. And so my advice is, again, make sure that we're using a SOPPA compliant and district supported avenue for that communication. And my advice generally to school staff is let's not text, let's email or use another district supported app or avenue for that communication. That's what I think is really important to keep in mind. And then we start talking about students, communication about students, special ed matters, other cases by text message or social media posts. that certainly comes back to haunt us. And we want to think about those implications for us and what that means from a student records perspective. But we also think about that from a FOIA perspective. We do have a binding PAC opinion this year over sort of that email search and search terms issues. So, this is PAC opinion 2307, where there was a FOIA request to the Chicago Department of Planning and Development. And so in February, the requester submitted a FOIA request for all emails sent or received by the Department of Planning and Development in the calendar year 2021. All are in part related to the city-owned property at, and here's the addresses, and here are the key terms. So there sort of gave some specific search terms. And, originally the city denied that, saying that's too many records, too many emails, it's unduly burdensome, when we get there. But, in the answer here, they said, look, in this binding opinion, the PAC said, when we get these requests for records, particularly emails, frequently this requires public bodies to make judgment calls about the appropriate personnel to consult with and the manner that it's to conduct its search. And when that request for emails is not expressly limited to specific employees or email accounts, FOIA doesn't require us to search every single account, but that we can make an adequate search by using judgment, identifying the employees whose email accounts are reasonably likely to contain those responsive records, taking measures to reasonably calculate those records. That's made on a case-by-case basis. And that we're often more knowledgeable than members of the public about, which email addresses to be able to search. And so in this case, they said, look, you had to do the search. That it wasn't overbroad. They gave you some specific search terms. But I think this is some helpful language here to say, but we still get to exercise some discretion. So we are making that reasonable search tailored to the nature of the specific request. That's what we're looking for in terms of that piece. But, and I think this is always an important reminder for school staff, that might include personal accounts and devices if you're discussing school district business. We've got more than one court decision on this over time. The older decision that's 10 years old now from the city of Champaign, where the News Gazette FOIA'd the cell phone text messages sent by members of the city council during meetings. And the city tried to say, wait a minute. Those are their personal accounts, right? Those are their personal email addresses. Those are their personal Twitter accounts where they're sending direct messages during meetings, so they're not subject to FOIA. And the court said, no, it doesn't matter the account if it relates to the transaction of public business. And we've got a similar decision more recently involving the city of Chicago in 2020, where again, that public officials' emails and text messages in their personal accounts were still subject to FOIA if they pertained to the public business, which makes us, have to really step back and say, how do we manage that, right? How do we effectively manage this if employees are creating all these messages? And I think that this comes back to trying to answer these few questions in terms of, do we have the right system in place to manage and maintain records so that if we need to search that we can, and that we can do keyword searches to find, emails and Google chats and text messages that might exist if we've maintained them that might be responsive to the request. So being able to do that and have the maintenance in place and understand the search. I think another piece of this is just training staff about recognizing where they should be communicating and where they shouldn't, what accounts they should be using and what accounts they shouldn't. The reality is, especially when it comes to student matters, that personal accounts, personal free Gmail accounts, your Twitter or X account, whatever it's called now, using Facebook Messenger, or, what did I see? You make phone calls through Instagram now. Those platforms are never going to have the data privacy or measures, that are compliant with SOPPA. I mean, here's the reality of how fast that works. Before we get started, Matt and I were chatting a little bit here about, using StreamYard, and one of my first times using this as a platform. And during the few minutes before we got started, I opened my Facebook, and I've got ads for StreamYard in my Facebook, right? That's how fast it works, And if we're allowing staff to, use any of those platforms that are not going to be SOPA compliant, that's going to be a problem, certainly from a data privacy and SOPA perspective, but also when we've got to go out and collect those records in response to a request, and that we're doing our appropriate due diligence in that regard. So, which I think leads us to a question here in the comments that I think is important. If somebody, FOIA's a personal device, whose responsibility is it to gather that information? I mean, ultimately it's the public body's job to do a diligent search. I think that's why the advice, of course, and to slide back a couple of slides here to my advice about this, is why we use our personal accounts for personal business and our school account for school business. Because if all of that communication is on your school account, nobody has to search your device, right? The device doesn't matter because it's in your school email account, it's in your your teacherees, it's in your Class Dojo, it's in your Remind, it's in ProCare, which so we don't have to worry about searching someone's device because they're using the right app or email for that. And so I think that ultimately it's up to the public body, it's up to the district and the district's FOIA officer to make sure that they're doing their due diligence when it comes to search, which certainly has to mean asking the right questions, and ensuring that the employee has tried to, provide any records responsive to the request. At some point there are limits in terms of if they're lying to us or they illegally delete records when a request is pending, which might have separate sanctions and separate considerations, and even might be potentially criminal in certain situations. Those are certainly considerations, but it's up to the public body to ensure that you've done your due diligence in terms of making that, as going back to the language here from the PAC, a reasonably tailored search, right? That's what we're looking for. Another question here: what platforms are not compliant? Well, that's a big question that we could spend a whole hour going back to SOPA. But remember, there are some very specific requirements under SOPA and under policy to make sure that all of the platforms that we're using, that there must be a written agreement between that vendor or operator and the school district, that agreement has certain terms related to cybersecurity and security measures and data privacy, that vendor is guaranteeing that they're using the reasonable security measures required by ISB for that purpose. And the reality is many of those platforms that are social media based, right, are never going to be compliant because those user agreements don't meet those basic data privacy protections. Back to that example, why I can talk about a product and have an ad for it in a social media account. That social media account is mining data, right? That's what makes a free Gmail account free, because you're paying for it with the data. There's no data privacy with Google, outside of things that are subscription based where you're paying for that data privacy, right? So we want to make sure that we're not using public facing accounts, social media based accounts. So ultimately, in order for a platform to be compliant, there has to be a written agreement with the district that includes those data privacy considerations. And a great way for districts to manage that is through the LTC's data privacy group. And those are things that are out there, to actively think about, and make that a lot easier for you. Because ultimately under SOPA, a teacher should never be using for any student information. No school staff member should be using for any student information, any electronic platform that there's not a written agreement that complies with the data privacy pieces in the law. So we've got a few minutes left here to think about questions. So please let's jump in and see what other questions are out there for us in this front. So don't be shy. Pop them in the comments. I think on any of those three topics or anything else school law and technology related, we can certainly think about and talk about here in our last few minutes together as we think about whether that's AI, those cybersecurity and SOPPA issues, electronic records issues, and anything related to that. I know we didn't talk a ton about social media. I did mention that one Sixth Circuit case today. We continue to see that being, an important area where the First Amendment jurisprudence continues to evolve among the circuit courts in terms of understanding that the ability to discipline students for off-campus speech is limited to those four areas of serious and severe bullying and harassment, threats aimed at students and other teachers, failure to follow rules about remote learning, and cybersecurity breaches, certainly being within those four areas the Supreme Court articulated for us.
Well, we'll pause here for just a moment. And if you have any questions at all for Brandon about the topic today, please feel free to drop those in the chat. As you can see, Brandon is super responsive to any questions you may have. And so this is your opportunity. Going back to that previous question, I dropped in the chat a direct link to the LTC's sort of jumping off point to the Student Data Privacy Consortium. You can search for compliant programs in there, platforms in there to help, I believe that was Chris, to help answer those kinds of questions. That'll show, which vendors already have agreements in place. And that makes it really easy to piggyback off of someone else's agreement to get an agreement for your district. But, it's not limited. If you want to pursue something and you can get an agreement signed with someone else, we can post that, get that listed there as well for other districts to help out other districts also. And do make sure you have a link to all the approved activities or platforms, I should say, that your district is using, linked to your website too.
Yeah, that's right. I know that I feel like we've talked about SOPPA many times in these, and there's so many good resources out there from the LTC on that, but there are a lot of very specific requirements that are there. And I know we painted with a broader brush today, but please pay close attention to those requirements. I feel like when it all went into effect, a couple of years ago, we all did a really good job that summer to get everything in place. And are we keeping up with it? That's the question. And some better than others. Probably all of you are listening today, so you know the right thing to do. So you're all keeping up well with it. It's all your naughty friends in districts that aren't listening today who aren't keeping up.
Right. Absolutely. I see Chris gave us a little response there. Again, Chris, it all depends on what you put into ChatGPT to decide how you can get a defense out of that. So, and that's a whole different webinar.
That's right. That's right.
Let's see. Phil has a question. What about tools like Remind for text messages? We had a student group use the Remind app to use as their communication platform, but this group was not district sanctioned activity. Someone used hate speech on it. The group sponsor said, as a school district, we should do something about it, even though it was not a school district account.
Well, yeah, I think there's two different issues embedded in that question. First of all, if the district has, an approved data privacy agreement with the Remind app, then that's certainly that can be used. That's one that's a frequent app that's used often by school districts. So I'm presuming that it's on the list, right? And as one that districts could elect to use. So, but I think two things: if a student group is using it, then it needs to be approved. And so I want to make sure that if a student group, if it is a school student group, even if we've got to make sure that they're only sticking to avenues for communication or apps that the district has approved. And if the district has said, yes, Remind is one that you can use, then I think that that's fine. So one, whether or not that student group should be using the Remind app is going to depend upon whether or not there is a valid data privacy agreement under SOPPA with them. And then I think the second piece is that something that school district should intervene from a discipline perspective? Yes, I think even if it's not approved, you've got a potential, cyberbullying or harassment or other issue there where it's not appropriate. You certainly have the ability, depending upon the content, without the details, that might be an avenue where you have both the ability and perhaps a responsibility to act, even if it wasn't approved. And so the worst scenario would be it's not approved and you don't follow through on the discipline. If it was a harassment, now you're losing twice. So let's make sure we're using an approved avenue for communication and make sure we're keeping up with our obligations to remedy situations where there might be violations of school policy related to school activities.
And I kind of coattail on that too, Brandon. There used to be different levels of service that Remind would provide. If it's an individual teacher using a free account, the ability to grab the transcript might be different than you might have with a district level account. So that's also
that is true. As you say that reminds me, because my kids' school doesn't use Remind, I don't have as much direct experience. I don't have Remind on my phone. I've got several others, because nobody wants to use the same one, right? So I have to have, multiple options that are there for us.
And Phil says that it was not a school account. So, that's tricky.
It is. It's harder to govern, but you may still have, just like any other platform, whether it's by Instagram or TikTok or Snapchat, you may have a similar obligation to act on it.
Chris also mentions a lot of teachers are using AI for lesson planning and curriculum development. Nothing wrong with that.
I would say nothing wrong with that from a general perspective, right? I mean, the devil's always the details. So is what you're being generated good content? And that's where that educator is going to have to decide at the end of the day if that is ultimately good content or not, and is it aligned with the district's prescribed curriculum? Because I think that's the other thing we've got to come back to, because you can say, hey, I want you to create me a lesson on topic X, but does that align with the standards of the curriculum adopted by the district? That's an important question that we're going to have to know. And if you didn't feed that into it, it may not be what you got out of it, right? So that's an important consideration too.
There's a lot of they call them data hallucinations that those AI tools can confidently generate inaccurate quote unquote facts.
Well, and we see that in the legal world. There have been multiple attorneys get in trouble by using AI to write a legal brief, and it's making up court citations. It's saying things that might not be accurate citations because of the way it's mining that data for its information to learn from. And we see some attorneys who have been sanctioned around the country because there are those data hallucinations in what's being put out there, and then you're making statements to the court that aren't true, and that's a big no-no as an attorney.
Right. Also, again, I'm riding your coattails here. As far as using it for using AI for generating, accommodations for IEPs and things like that. Just want to reiterate for everybody, never, ever, 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 ever put specific personally identifiable information into any chatbot anywhere for any reason whatsoever.
Yeah, I mean that privacy piece to that is always a tough piece.
Mm-hmm. Any other questions out there? Okay. Well, not seeing any hop up here real quick. I think we can probably draw this to a close. So thanks very much for everyone who attended. This does close out our fall webinar series. So thank you, Brandon, for helping us bring this to a close. We're happy that you all joined us. This video will be posted on YouTube at Learning Technology Center, all one word, shortly after we're done here. Probably tomorrow morning at some point, I will put a link to some of the information that Brandon has provided for us live into the video description there on YouTube. So that'll be your go-to to review anything or look in a little more detail. So Brandon, thanks so much for your time today.
Thanks again. Great to see you all.